Good afternoon, everyone. This is Danny Jovica here and the IMREAL.LIFE channel, and today we're doing another FLAST case review. This is one about a father appealing parenting orders. These are final parenting orders where the mother is to have sole parental responsibility for the children, and that they live with her and spend time with the father on alternate weekends and for half of all the school holidays. So dad has lost parental responsibility, which is a fairly significant event, and the children are going to live with mum and only spend alternate weekends with dad, and dad is not happy. And he's appealing this decision. The facts of the case: the children are now aged 9 and 6 years respectively. The mother's also got an older child of a prior relationship who's aged 15. And the father is challenging these orders where that relate to the parental responsibility, relate to the residence and spending time, and the father's actually supported by the independent children's lawyer, but opposed by the mother, of course. So an interesting case. So after the relationship of 9 years, the parents separated in 2017. So only about 5 years ago now, or 4 years ago now, at a time where there was an incident between the parents to which the police attended. So they separated. There appears to be some domestic violence that occurred, which was the trigger for the separation. And thereafter, X, if we go back up here, is the 9-year-old, lived with the mother, and Y, who was then not yet 3 years old, so 2.5-year-old child, lived with the father. So that's interesting just in itself, because normally you would have, if anything, the older children staying with the father and the youngest being with the mother. So it's quite an interesting scenario that exists there. Now, neither parent would agree to the children living together. So that also seems quite bizarre in some way, that why neither parent would agree to the children living together. But I guess it sort of means that the father didn't want the child that was living with him to live with the mother, and the mother didn't want X to live with the father, as opposed to anything related to the children themselves, of course. With such a young child at 2.5 years old, it's hard to imagine there'll be any issue other than that. So what happens next is even more interesting. After about 6 months of this, the mother removed Y from preschool. So you got a 2.5-year-old. Now that 2.5-year-old's turned 3-ish, and dad's got the child at preschool, and mum's gone to preschool and kept the child. Normally that would be the subject of some sort of recovery order. But the parents entered into a parenting plan, which provided for the children to spend alternate weekends with each parent. But after a short time, the mother withheld the children from the father. So despite a parenting plan being in place, the mother's now withheld altogether both children. So on the 30th of October, a judge of the Federal Circuit Court made interim orders at that stage that the children spend time with the father on 2 weekends out of 3. So obviously what's happened here is, as mum was withholding, dad's gone to court. He's got interim orders that he gets to spend time with the kids on 2 out of every 3 weekends. By the time the trial commenced in August 2019, so that's almost a year after those interim orders were in place, the children lived with the mother since about June of 2018. And typically what a court's going to do here is have a look at that situation and say, well, since June 2018, kids have been living with mum. That's been going okay. There's been no problems at home with mum, and dad's going to have a problem here trying to change that situation. And although the orders have gone against him, as we set up here, he's appealing that, but I think he's going to have some difficulty here. The orders under appeal resulted from a discretionary judgment. So the judge has used their judicial discretion at interim stage. That's pretty much what the judges are going to do, because at that point in time, the court has not yet had the opportunity to weigh those facts in that case. You know, the parties are both going to be submitting their evidence and saying, you know, this is what, you know, has happened, and in this case there's domestic violence involved as well. So there'd be allegations that the court needs to sort of sort through and weigh. And at this stage, it's not looking good for Dad in terms of this appeal as well, from what I can see. The family court report writer concluded that neither parent presents as being able to encourage and support the children's relationship with the other. This is always a problem. So whenever I see something like that, it's a difficult situation the parents are putting the court in. Because effectively, if the parents are saying that we can't work together, we can't co-parent, that there is a non-existent relationship there for co-parenting, it forces the court to pick one over the other almost every single time. You're never going to have, or very, very rarely are you going to have a situation where the court now somehow makes this equal time. Especially when the parents can't work together, can't cooperate together, and there's domestic violence and hostility involved. So the issue here is whether or not the primary judge failed to engage the father's case and assess the evidence that the father has made. And in appeal cases, the problem with that kind of an argument is it's not just that you have to sort of prove that the judge didn't fail to engage the father's case. I mean, I don't even know what that really means, and assess the evidence and make appropriate findings. It just sounds to me like the judge didn't rule the way the father wanted, and that's what's being appealed so far. And the difficulty here is what the father's got to be able to prove is that the judge acted on the wrong principle of law in making the decision, that the judge actually made an error of law, or the judge was influenced by either irrelevant or extraneous materials, or that the judge mistook the facts. The judge just didn't understand the facts of the case and made a decision not understanding those facts, or that the judge didn't take into account some material consideration, that there was something that was really vital that had the judge looked at that, it would have made all the difference, and that the result is unreasonable or plainly unjust. So that's a sort of burden of proof that you've got to sort of get over here when you're appealing a case. Now, a fairly recent case was cited as well, Manifold and Alderton. And in that case, it was held that the focus is not on the delay per se. So I guess we're talking about this kind of delay here, where mum's taken the child from preschool, it's taken a long time to get to court, and from then it's taken a long time to get to the point of a hearing and judgment. So the delay per se, but a failure by the primary judge to take into account relevant matters and engage with the father's case. So this is what that is up there. That's this engage with the father's case. That's his argument that his case is something similar to this case. He's arguing that in this particular case, the court favoured the appeal favoured the father, and he should be treated in the same way because the judge didn't provide adequate reasons for the conclusions. So if we have a look at the analysis of the case, there was no error asserted in the primary judge's recitation of the grounds on which the protection order was sought. So, you know, when you're going to appeal, you've got to be able to sort of, no error is asserted in the judge's recitation of the grounds. So if you're not including a basis or a recitation of the grounds of appeal that, you know, the judge did something wrong, then what are you basing your appeal on? Clearly the primary judge relied not on the police report as counsel for the father submitted, but on the grounds relied upon in the application for the protection order. So they're sort of arguing that the judge should have looked on the police report as the counsel for the father submitted and not on the application for the protection order. Okay, this I think we need to have a bit of a closer look at. And in all FLAST cases, we have a link at the top there to the actual case. So if we click this link and open that in a new tab, that's going to bring us to the actual judgment itself. Let's just sort of scroll down here for a minute. The respondent, in this case the mother, is self-representing here as well, which is interesting. And you got independent children's lawyer involved, and counsel for the appellant is, so the father's got, this is from out of Brisbane, by the way. The father's got a barrister and solicitors representing him, while the mother is self-repping. So here's one for the books on self-repping, I guess, against a barrister and solicitors. So if we scroll down and look at what were they talking about. Ground one, the primary judge failed to engage with the father's case and assess the evidence and make appropriate findings. The primary judge assessed the competing allegations and concluded at 14 that this matter is a fairly fine balanced matter with dreadful behaviours by both parents in terms of the way they interact with the other parent and their view of the other parent. So, you know, they hate each other, it's pretty much clear there. And at 45, this case is one where each of the parents' evidence about the other is completely unreliable. You know, and you often see this in cases where the people will just throw all sorts of allegations and, you know, throw as much mud at the other party as they can and hope that something sticks. And that's what it looks like has happened here, where the judge says, I cannot prefer either of them in terms of the truthfulness as a witness. The judge can't make out who's telling the truth and who's lying here, and because it's just the volume of attack on each other. The mother's evidence was inherently inconsistent on many occasions. But the father's evidence included odd behaviours. Maybe he was nervous by him laughing at various things. But the father's own attitude towards the mother is so resolutely negative, it is hard to see how I could take at face value anything he says unless there was some corroboration. So there's a key word there. You know, if you're going to make allegations about another person, you've got to have some witnesses. You've got to have some witness statements that you've submitted. Don't expect that the judge is going to take your word over the other parties. And in this case, the father didn't have any corroborating evidence. If we scroll down a little bit more, let's just have a look at what happened. At the point of separation, this is what, there was an incident where the police were called. And The police, in their grounds for a protection order application on behalf of the mother, the respondent violently attacked the aggrieved. So he violently attacked the mother in her rental property, leaving her car keys bent and broken, and her right hand lacerated, bruised, and swollen. So there was a physical altercation. The respondent dragged the aggrieved across the front lawn and the front of his front lawn and the neighbour's property by enclosing her already damaged hand under his own over the handle of a bag of clothes to mask his grip on her, in front of various neighbours and all the children, X, Z, X, and Y. Well, now Dad's now wondering why the decision went against him, and his argument is I'm not sure. He wanted to look at the police report. Well, this is the police report, and it's not really looking good for him. When the aggrieved called the police, the respondent said words to the effect that there's no orders, the police can't help you, cunt, and shoved her repeatedly around the residence. So here's again an all too common thing when parties don't have court orders and they think that means they can do anything that they want. The respondent repeatedly kicked the aggrieved in the shoulder, right arm, and the aggrieved believes he was aiming for her face. When he realized that police were approaching from the street behind, he bent down and quietly said the words to the effect, "I'm going to take you through court and fucking destroy you." So, quite the charmer. The respondent's entire demeanour changed into a frighteningly calm and composed manner when the police arrived. So, obviously he's appealing this decision, but he's got to look at. He can't say that the judge didn't consider the evidence. The evidence was plainly considered there. However, here it says that it is clear that the matter was nonetheless given consideration by the primary judge. The mother is of the view that when she speaks of the father to the children would be wholly unaware that she has a negative attitude. The mother believes that she speaks about the father in some kind of bright, jolly way. They are my words, and that she is always keen for them to talk with her about what they have done at their father's place, or be supportive of them having time with the father, such that they might be completely unaware that she has a negative view of the father. Well, that's what the mother's saying, but it would appear that's not what actually happens, because the judges earlier on, commented on the fact how much how negative the view is, but the mother is saying that she's not making the children aware of that. Again, that seems unlikely, that the children would be of the view that their mother is wholly positive about their father. The mother is so completely the opposite of wholly positive about the father that it would be, it seems to me, completely unlikely that the children would be unaware of it. Well, there you go. Yeah. Now, the father, in his evidence, was the view that he speaks with the children about how they are coping in life and what they are experiencing, but he believes he does it in a way where he is shielding them from his view of the mother. So they're both claiming, to be, saints here in front of the children. So he will ask them questions or speak with them about how to assess whether somebody is lying to them. The father believes the mother is a compulsive liar. So, here he is, here's dad sort of teaching his children how to figure out if someone's lying. And that when the children tell him something, that they will say they've heard from her, his response is to speak with them about making an assessment as to whether somebody is telling them the truth or not. You're getting kids involved in adult things here, Dad, and again, the court's not going to like that. Although the mother here is turning around trying to say that she's, not speaking negatively of the father, and the judge doesn't believe that, here dad is already, digging his own grave in the way he's interacting here. So you can see, we'll go back to this digest here and the analysis, and it doesn't quite gel, does it? The father's lawyers' arguments don't really add up to what he's trying to say here. And counsel for the father refers to the police reports on the 15th and of June, November, December, in relation to a street check summary made by the police. However, there was no evidence made in the submissions by counsel for the father to the primary judge of any of those specific matters. So here's again a common mistake that we see, that during the primary trial, if you don't introduce this evidence, then you can't bring it up in an appeal. Whatever evidence you want the court to consider has to be brought up in the main hearing and in the primary trial. So, and then if you're appealing an error that was made there, not an error that you made because you didn't submit the evidence. Now, counsel for the father did not submit that any particular finding followed from that evidence. Hence, the father conducted the trial before the primary judge in a way which is at odds with the challenge he's now made. That's just what I was saying. As to the complaint that the primary judge didn't engage with the evidence of the mothers involving the children in the dispute, there was no submissions addressed to the primary judge in relation to that. So again, this is where it comes into it, that you think that, after how many years these guys are in court, you can't be introducing new evidence in an appeal, and you can't be, especially new evidence about something that happened historically during the time when that should have been brought up in the trial itself. So the primary judge was acutely aware of the negative attitude each of the parents had towards the other and the consequent effect on the children. No error of the primary judge is established by her failing to make findings that she was not asked to make. That is, again, your classic mistake that happens in so many cases where, people seem to think that if you submit some form of evidence, that the judge is going to look at that evidence and now make some decision on that evidence other than just weigh it just generally. You have to ask the court the question. If you submit evidence and you expect the court to address that evidence, you need to ask the court to address it. You can't just submit evidence and expect that the court is going to make some sort of finding there without being asked to do so. So naturally, the appeal is dismissed, and no orders for costs have been sought by either the mother. Well, the mother couldn't because she was self-repping, and the ICL also didn't seek orders for costs. So, look, another interesting case here, and unfortunately for Dad, it's not really like that. He's made some mistakes along the way and hasn't run his case quite the way he should have. The lawyers in his case, he's got a barrister and a solicitor again, so it was really up to them to turn around and advise him on this appeal and what his likelihood of success was. Unfortunately, he's going to be facing the costs of the court, his barrister, his lawyers, and licking his wounds on this one. So look, that wraps up the summary of this case. I want to thank everyone for being with me, and I hope you enjoyed this summary and this analysis of this particular case. If you like the videos and what I'm doing here, click on that like button and subscribe to the channel. That sort of gives me encouragement to keep going and keep doing these sort of an analysis for you. And in the coming sort of days and weeks, I hope to have a number of people joining me in these analysis, some lawyers and psychologists and people who are specialists in domestic violence are going to be on board. And I'm going to have some, ordinary mums and dads who have been involved in cases like, in either in property law or in, parenting matters, who have experienced these kinds of things and get their take on it as well. So if there's any of you out there who want to join me, drop a comment below and let me know, and we'll get in touch and invite you to join us in one of these presentations. In the meantime, thank you again, and we'll see you next time. Cheers.